For more on that matter, and of course the other matter coming out of the Constitutional Court, that of the parole appeal dismissal, we're joined now by political analyst Lukhanyo Vangqa and legal analyst Nthabiseng Dubazana. Good to have you both, and thank you very much for coming on. It does seem, by what I'm sensing from the public protector, that she believes it's the end of the road. There's not much more that could come out in terms of challenging this particular process. Nthabiseng, what do you think?
Good evening, Thabo. The network was a little bit bad, but I think I got the gist of your question. Yes, because this matter was heard in the Apex Court, the only step that is basically left is for the rescission application. And by virtue of making a rescission application, you're pointing out to the court that it made an error, either in fact or in law, but mostly in fact, in coming to the conclusion that it has. Yeah. So once the legal team of Mkhwebane has made a decision and perused the judgment as is and decides to make this rescission application, then most likely that will be the next step. But apart from that, we have reached the end of this matter, and we'll see how best they decide to go ahead with this matter.
Would something as maybe for me it sounds important, as the fact that the court says the Section 1 and 4 proceedings had started already, and she says no, they had not started. And there's a discrepancy around the dates. Is that something that would be weighty enough as far as the rescission application is concerned?
I believe it would. So it will be a situation where perhaps it will be an interpretation, like you just said, of the dates. If the court is of the view that the committee had already been selected and therefore that was a start of the 194 inquiry, then that's how they choose to view it. And if the legal team Mkhwebane says that no, the process actually started when the charges were read and everybody was like the way it is structured currently, that's when the 194 committee started or the hearing started, then it will be a matter of the court now having to decide which of these stages were the actual starting stages of this matter, and then make a ruling on that. And if the court still stands on their issue, wherein they say that once this committee was formed, it is sufficient to say that the Section 194 inquiry had officially started, then they may not rescind their judgment as a result. Perhaps another thing that they can look at, when I was listening to the judgment earlier on, just a little bit of it, Memaya said in her ruling that it was not irrational for the president to act the way that he did, in spite of there being other rational aspects that he could have used apart from suspension. Perhaps there could be another way to look at it, or to try and tap into the issue of rescission of judgment to see why didn't the court look at the other rational aspects that could have been used apart from suspension. Maybe that could be something they could look at. I don't know. So we will see how they decide to peruse and go forward with the judgment.
And finally, this matter that she's using of the late release of this judgment, is that something that should, of course it should bother the Concord that it's coming out late, but is it something that could work against this judgment of the Concord? At least in the eyes of the public?
Well, judgments usually, as you may be aware. Sure, I don't know what happened. I can't hear you properly, but I think you're asking whether or not the judgment coming late as it is a problem. It can be something you can use against it, but I don't know how weighty it would be to use it against the court to have its judgment rescinded or in any manner or form. We are aware that judgments are to be released within 3 to 4 months. That's the longest a court can hold on to a judgment before it releases it. Yeah. And now it's waited for almost a year, if not just a little over. And then thereafter they now slapped the Mkhwebane with personal costs in this regard. So in so doing, the term justice delayed is justice denied. The patrons who are involved in this matter did not have the leeway to prepare themselves for the possibility of whatever the outcome would have been. It has been delayed so long, and we look how far the Section 194 inquiry has gone. Had it been, let's say for argument's sake, that the vision that Mkhwebane's team has, that the inquiry had not started by the time she was suspended, if in the event that the court is in agreement with that, then it would mean that all that has happened from the time the inquiry started till today would be null and void. So we've wasted time, we've wasted resources, we've wasted money, but most importantly, her name has been dragged throughout the public in terms of her being incompetent, etc., etc. But in the event that the court still relies on their own version, wherein the inquiry had already started by the time she gets suspended, then it's a different ball game altogether. So, the issue of giving judgments early gives the parties to the matter access to what would be their next step while there's still a leeway for them to work, not in a situation where so many things have happened and compounded so much that you can't make way of what should happen next.
Right. Get your point. Lukhanyo, let's just talk the politics of this matter. The opening words of the suspended public protector is that, well, I expected this outcome. And she, of course, cites the court of public opinion, saying, well, it's already out there that the courts are with Ramaphosa. Suppose that's the political game that you would play.
Yeah, good evening, Thabo, and good evening to the viewers as well. Those sentiments are unfortunate, and that they exist are unfortunate. They serve to test confidence in our judiciary, and that's never a good thing when the judiciary is brought into question. But on this judgment itself, this is checkmate. This is a decisive battle, and the fact that it has gone Ramaphosa's way sort of puts to bed this 4-year war of attrition between Ramaphosa and Advocate Mkhwebane, acting as the PP at the time. And she joins the list of vanquished Cyril Ramaphosa enemies. Ace Magashule having been expelled, Jacob Zuma going back to jail. You can look at Zweli Mkhize as well. So she joins that heap of vanquished Ramaphosa enemies and frees Ramaphosa to now focus on new emerging political enemies that might come up in this year. But this puts to bed really this war of attrition that we've seen between Ramaphosa and Advocate Mkhwebane.
These are what would call wounded enemies that are out there, that are still limping, are completely out of the picture. I mean, they are seriously wounded, and they have reason to want to come back. Does it, I suppose, solidify their banding together of wounded soldiers to mount some kind of a fight back?
I don't think any fight back is really possible at this stage. They really are vanquished by Ramaphosa. And you look at the state of each of those individuals, where they are in. Zweli Mkhize is in the political wilderness. Jacob Zuma is battling to stay out of jail. Ace Magashule has been completely expelled from the ANC, the biggest political party in the country. So Ramaphosa really doesn't have to worry about those anymore. Now his focus can turn to the new emergent political enemies, such as an inconvenient deputy president, such as a recalcitrant and defiant Minister of Minerals and Energy, Nthabiseng, and also the 2024 elections that promise to drop the ANC below the 50% majority for the first time since democracy. So those are the new political battles that Sir Ramaphosa can switch his focus to. With regards to Advocate Mkhwebane and all the others, I think those have now been vanquished politically.
As far as this question of lawfare in terms of their political fights, it has not worked well for the advocate, has not worked well for Ace Magashule. It doesn't seem to be working well for President Zuma, of course, considering the private prosecution fight that he keeps losing. Is it beginning to send some kind of message, maybe to politicians, that the lawfare route might not be as easy as they think it would be?
There's a cross-pollination of these issues, Thabo. You look at the Ramaphosa versus Mkhwebane war. Those battles have raged across all three arms of government. They've been fought in our parliaments, they've been fought in the executive branch, they've been fought in our courts. And the same thing happens as well with the ones that you've mentioned. So there's a cross-pollination of these battles across all three arms of government. And Cyril Ramaphosa seems to have emerged victorious in all three of those arms or those sides of battle. And that's not surprising. He's an incumbent. The power of incumbency brings with it a certain fortuitous streak with it. The same thing happened with Jacob Zuma, if you remember. He had all his cases squashed. He was in charge and in control by 2013, a year after he got his second term as ANC president, and really he was the man to beat. And the same thing could be said for Thabo Mbeki after he emerged for a second term in 2002 in Stellenbosch. So that's what happens with the power of incumbency. You become sort of invincible until you are in your last 2 years or so of your second term. Then you become very vulnerable as a president. So we'll wait to see what will happen with President Ramaphosa as he chases down to his last 2 years or so of his second term.
Ooh, I would have loved to take this conversation a little bit further. But because of time, unfortunately, we have to leave it there tonight. Nthabiseng, Dubazana, appreciate your time. Lukhanyo Vangqa, thank you very much for coming on tonight.